Hello, everybody. This is Cyrus Mehta. Today, I'm going to talk to you about an obscure provision in the Immigration and Nationality Act that the US Supreme Court is going to take up very soon in a case named United States versus Evelyn Sineng Smith. INA 274A1A4, which we will call the encouragement provision, broadly prohibits any person from encouraging or inducing an alien to come to, enter, or reside in the United States, knowing or in reckless disregard of the fact that such coming to, entry, or residence will be in violation of the law. The encouragement provision could potentially criminalize the advice an immigration attorney routinely provides to a client. Even though this provision has been around for 2 decades or so, it's rarely been enforced. But now that the Supreme Court wants to take it up, it's going to get more attention from the government. Here are some examples where a lawyer could face danger. A lawyer may advise a client whose citizen child is turning 21 in 2 years to remain so that she can adjust status in the United States, and this person is currently unlawfully here. Another client is imminently going to marry a US citizen, but he entered without inspection and is not eligible for adjustment of status. Still, he may be eligible to file an advance waiver application, it's known as I-601A, to waive the 3 or 10-year bars based on a qualifying relationship with the prospective citizen spouse. A lawyer who competently advises the client to remain in the US during the pendency of this application could get snared under the encouragement provision for encouraging the unauthorized non-citizen to remain in the US in violation of the law. This provision is really broad. The Supreme Court has now agreed to review the constitutionality of the encouragement provision. Why? Last year, the Ninth Circuit in the same case declared the encouragement provision unconstitutional as it was so broad that it could criminalize speech protected under the First Amendment. The government was not satisfied with the Ninth Circuit's decision and has now taken it to the Supreme Court. It's really strange that the Supreme Court decided to hear this, but here we are, and we hope that the Supreme Court would agree with the Ninth Circuit. The good news is that AILA, along with many other nonprofit organizations, has just filed an amicus brief persuading the Supreme Court to do just that. The amicus brief brilliantly argues that the encouragement provision criminalizes broad swaths of constitutionally protected immigration advice, even if this advice is competent and ethical, as there are many benefits that non-citizens can only obtain if they are present in the United States. An immigration attorney can still be prosecuted under this provision. Like any other kind of speech, immigration advice is protected by the First Amendment, and advice by attorneys has a special place in our constitutional system. The Supreme Court in Upjohn Company versus United States has taken care not to restrict, but to encourage full and frank communication between attorneys and their clients. This is mentioned in the amicus brief. Given the significant complexity of various immigration laws and policies, the need for full and frank legal advice is particularly urgent. The ultimate consequence for violating immigration law is deportation, which can be more draconian than a criminal penalty, such as a short jail sentence. In Bridges versus Wixon, the Supreme Court once held that deportation visits a great hardship on an individual and deprives him of the right to stay and live and work in this land of freedom. The most prudent approach is for a lawyer to refrain from expressly advising or encouraging a client to remain in the US in violation of the law, and instead present both the adverse consequences and potential benefits to the clients if they choose to remain in the US in an unauthorized capacity. Such an approach would also be prudent if the Supreme Court upholds the constitutionality of this encouragement provision, even if the government has asserted in its pleadings that it will enforce the law in a limited manner. Regardless of whether the encouragement provision is upheld or not, a lawyer's conduct should be guided by rules of professional responsibility. Significantly, ABA Model Rule 1.2d states that a lawyer shall not counsel a client to engage or assist a client in conduct that the lawyer knows is criminal or fraudulent, but a lawyer may discuss the legal consequences of any proposed course of conduct with a client and may counsel or assist the client to make a good faith effort to determine the validity, scope, meaning, or application of the law. Still, it would be best if the Supreme Court voids the encouragement provision as unconstitutional. A lawyer should be able to give full-throated advice to non-citizen clients regarding applying for benefits under the Immigration and Nationality Act while physically present in the US and even if here in an unauthorized capacity. Until that happens, a lawyer who practices within the confines of ABA Model Rule 1.2d, such as presenting the legal consequences of remaining in the US or not, rather than actually telling the client to remain, should be more insulated and protected than a lawyer who does not. Thank you very much.